Humphrey's case, and I know you wanted to talk about the Humphrey's case as well, that's what the Supreme Court just ruled. That was a story about the guy that robbed somebody. He took $5 in a bottle of cologne, and he had a $350,000 bond. Once again, that's the narrative being told by the other side. But the reality is he only took $5 in a bottle of cologne from the guy because that's all the guy had. If the guy had $1 million sitting on his nightstand, he would have taken the $1 million. What they also don't tell you is he was threatened to smother the guy and kill him with a pillow. And this was an elderly gentleman. So it wasn't like, and they also don't tell you it was his fourth strike. So this wasn't a guy that had a clean record. This wasn't a guy, he was in jail. Did he deserve a $600,000 bond? No. But he went back to court, 48 hours, the court lowered his bond. Now, then he sat in court for a really long time because there's no way he was going to afford that bond either. So that ruling that just came out on the Supreme Court regarding that Humphrey's case basically was just saying that the appeals court got it right, is that judges need to take into consideration the amount of money that somebody can pay. And in a way, they kind of already do that, though, right? I mean, Nicholas Lindblad, you get a $10,000 bond. Michael Jackson gets a $5 million bond. Why? Because $10,000 bond, it's not going to hurt Michael Jackson if he doesn't show up. So they take that into consideration already. So it was just kind of solidifying, I think, what's already on the books is that judges need to take the amount of money someone has into consideration, as well as other things, their flight risk, the risk to the public, and all those different things. So it just really says what's already on the books and what they already do today.
Yeah, and what people generally don't want to give, or maybe they just don't care to ever ask and find out, but when bails are set to an excessive amount, that doesn't help anybody. All it does is incarcerate somebody. So you have somebody and they got like some huge bail amount. How can they qualify for a bail bond? It's not just about submitting premium, which they probably don't have either, but how are you going to like get the authority? You work for a surety company. How am I going to be able to write on AIA paper a $250,000 bail bond unless I have co-signers who are perhaps homeowners, or maybe they have like a fair credit rating, or maybe they have, some sort of credentials that say, hey, they've been in this certain area, born and raised, they're not going to just take off because they're, non-residents or something like that. There's so many different factors that go into having just a $250,000 bail actually get written. It's not even just about the money, but a lot of people don't look into that. They see excessive bails, and we too, as bail bondsmen, see excessive bails. And then we just sit thinking, well, what could anybody do? They can't afford to put up the full amount of the cash. They can't qualify and pay for a bail agent. The bail is set too high for this specific person. It circles back to what I think you're saying is it needs to be set, and the key word is to a sufficient amount. Yeah. So Michael Jackson has one amount, Nicholas Lindblad has another amount. The person with the terrible failure to appear history might have a different amount because their history says that they're unlikely to return to court. It does have so much to do with what a sufficient amount is. And bail bondsmen have been in it, like, we all agree on this for so long, yet I wonder why people want to point the finger at us when technically there still is pretrial services. There still is petitioning the court for reduction. And yet the lion's share of the blame is on the bail bondsman.